In a democracy, justice plays a crucial role, serving as a foundational principle that ensures fairness and the protection of individual rights. Justice is also closely tied to the rule of law, which means that laws apply equally to all individuals, regardless of their status. Now, this principle helps prevent subjective governance and protects citizens from abuses of power. Let's just say that justice is integral to the functioning of a democracy. Today, we look at the judicial system we're operating in the country and how well it is placed to ensure that justice prevails in our society. Our discussion today on Newsnight is with the president of the Nigerian Bar Association, Afam Osigwe. Hello, and thank you for being with us on the program.
Thank you for inviting me.
And thank you for accepting our invitation.
Thank you, Larry.
Okay, so I think I would like to start from your position as the president of the NBA. The NBA is one of those organizations that stand out when you talk about unions in the country. And I would like to understand, how has it been being president of the NBA?
Well, it's been mixed. It's been good, stressful, interesting, and very exacting.
Okay.
Our members look up to us. The society looks up to us. So there's a whole lot for us to do. And then as a person, I made campaign promises, which I have to accomplish in the context of lawyers' expectations and societal expectations. So it's been a very interesting, even though exacting ones. It has affected my private and family life. It has also affected my professional practice. But then it's a call to service, and I'm glad that majority of our members deem me worthy to be given this responsibility at this time, and I'm not complaining.
Okay, now you know, one of the things I think has been very interesting for me has been the large number of lawyers that we're churning out. Right now, it appears more than usual, and the space, I don't know if it's growing, and how they're able to meet up with their professional desires in the field. What has been your understanding of?
So statistically, Nigeria is under-lawyered.
Wow.
The percentage of one lawyer to a certain number per population, we're yet to meet it. And even though we have, give or take, over 120,000 lawyers on the roll kept by the Supreme Court, about 80,000 of those are in practice. And then some are in-house counsel, some are in active practice, as we say, some have gone into other things like politics, like business, and some other endeavors which do not require them utilizing their knowledge of the law, but they are lawyers and their names appear on the roll. So from that perspective also, we don't seem to have enough lawyers. And with a growing population like ours, it's only natural that more people would want to read law. It's only natural that more people wanting to read law, and as more private universities spring up, as more federal universities offer law or seek to increase the quota of number of law students they are permitted to admit, the more lawyers will be turned out into the society. And a number of these lawyers will also join the brain drain, leaving the shores of this country to seek greener pastures elsewhere. So while there may be need to focus on regulating the profession to ensure that the right persons get into the profession, I think the emphasis should be on the quality of legal practice rather than on the number. A number of people who are reading law today, not because they want to read law, but probably because their parents wanted them to read law, or they just didn't have much choices as to what other course to read, and they chose law with no intention of ever putting it to use. Some are taken to entertainment, some are taken to so many others, some are even taken to tech, some are taken to show business, some going into even fashion designing, so many things, so many unimaginable things, things I would never have imagined that a person with a law degree would get into in Nigeria. But either in a bid for survival, in a bid for diversification, or in a bid to ensure that they put their creative talents or abilities to use, some of these lawyers are more and more taken to some other things other than law. So I say that we don't have a large number of lawyers in the real sense of it.
But in terms of what you were talking about, the issue of quality, in terms of the training through the schools, you feel we're still where we should be, or we still have more to do?
So I think we have more to do. I think we should focus on the content of our legal education. So you see many employers or many senior lawyers complain that the quality of lawyers joining the profession is dwindling. And some argue that they had it better in their days. What my thinking is that if we focus on the quality of legal education people get in the university, that will produce better lawyers. We think that the law school will do a magic. That in a 10 months or thereabouts it takes to actually train the law students that will make them overnight wonderful lawyers. It cannot work that way. It can't work that way. If you don't lay a solid foundation in the university, you can't expect the law school to magically turn them into super lawyers. So we have to look at the university curriculum. You need to look at some of the courses that will teach them and ask ourselves whether they are really relevant. And also look at what I call the rote learning system we apply in the university, where you are simply expected to cram things and give it back to the lecturer the way he taught you. Never mind whether the lecturer was right or wrong. Where students are not really, where emphasis is not placed on analytical thinking. Students being able to think on their feet.
Or have confidence in the quality of their own.
Yes, and also being allowed to disagree with their law teachers and still pass. Not being assessed for their ability to reason on their feet, to think, but for the ability to remember that which they were taught. Is also affecting the quality of people. And the Gen Zs, the younger generation coming up, want to question the status quo.
Yes.
And they are not contented with telling you what you have taught them. They have the mind of them. They want to ask questions. And it would appear that generally a system of teaching does not permit that. Well, they have what they call legal clinic in schools at the moment, but we could go further to allow for some degree of independence of thought, for not having one perfect answer to every question. There shouldn't be one size that fits every situation. Students should be able to think out of the box. That is the only way you liberate their minds. That is the only way you make them good thinkers. Think creatively. So that if they decide to join the practice of law or you join the profession in one way or the other, they will be able to come in with a mind that is fertile with ideas, a mind that is able to reason broadly and be able to give good services to those who may need their legal services, or which they will be able to use in wherever they find themselves or what they choose to do, but not a mind that has been forced not to think, to accept things as it were, without unquestioningly. I don't think that makes for the best of training.
Okay,
so that's I talk about quality.
Quality.
And like I said, some of the courses in my thinking are unnecessary. You shouldn't waste anybody's time. For a student who spends 5 years and will still complaining, it means that there's something wrong with teaching
fundamentally with that. And this is interesting because, some will tell you which the distinction should be made. You're talking about the quality of the mind, because some will still say that the legal profession is a profession of traditions, of the way things should be done, of ritual, the clothes you wear, the way you behave to senior colleagues and all that. But when it comes to the mind and the confidence, which is what you are talking about, students should be.
Oh, yes. When it comes to the tradition, deference, and then all that, of course, we should maintain.
But some people are questioning even those, what should I wear, what should I not wear, and all.
For as long as we are humans, that argument will continue. And I read a news article this morning, or was it last night, about the president of, is it Niger or Benin, one of these Mali or something, changing the way people dress to court, calling them vestiges of colonialism, that we need to liberate our minds and how we dress. And according to him, say you cannot fight colonialism by wearing colonial clothes. While I may not adopt his model as my argument, the point is that people will someday even question the continuing relevance of wearing wig and gown to court. Why can't we just wear them during ceremonies? Our weather does not permit it. And most of our courts lack the air conditioning suitable for dressing in that mode. Why do we have to wear horsehair to go to court? And people who look at the history of this say, look, we have no reason to wear it. But they also, from opinion poll done last year by, I think, Professor Ojukwu or somebody, that majority of lawyers are not in a hurry to jettison the wig and gown. They say that is what makes them lawyers. While I do not agree with that, because I don't think the hood makes the monk. Whether you wear wig and gown or not, you can still be a fantastic lawyer.
Yeah.
But the moment empirical evidence seems to support the continued use of the wig and gown. If I'm to, I'll say we should only wear them during ceremonies. But I'm not the majority, and so I'll wear it just like every other person. point, people will always question the status quo. People will always question certain things. It is the test of passage of time that will show whether some of these things stand the test of time.
Yes.
But my point is, there must be some traditions in the profession which we must hold sacred. When people's ability to think and disagree should be so fertile as to be predominant in our profession. And that is why a court can be persuaded to depart from its earlier decision in the light of emerging facts and argument or law which show that thinking no longer represents the state of affairs.
Yes.
With a mind that is stopped from thinking, you can't get such a change of position. But with a mind that is fertile with ideas, that is able to say, yes, we did it like this, but I think we could do it differently and society will be better for it.
And with supporting argument.
With supporting argument, of course. It's not an emotive thing. You have to really, really show that decision may have served its purpose or was decided wrongly or is no longer in sync with the changing times and circumstances.
Okay, I think it's a good one to also consider. Now, let me take you to the profession. We've left where they are coming from. Let's come to where lawyers now practice. And I think just like with life, school life and reality are two different things. We have a judicial system that is in need of a lot of change. I can talk of delayed cases, controversial judgments and all that. You are the one in the field. Would you say that the courts or the legal system still remains the hope of the common man?
Without doubt. Despite the shortcomings, despite the negative perception that the judiciary has not done well, we don't have any other choice. We can't have it differently. Because to jettison the judiciary will mean to say, all man for himself. Will become wolves unto each other. And that will be worse than the worst judiciary system. And so, yes, there may be deficiencies, there may be shortcomings, there may be unmet expectations by the people, the perception may be this or that, but it remains the only way for another society like ours to be able to resolve disputes, aside from the party-driven ones like mediation, arbitration, conciliation, or the customary arbitration and all that. The judiciary remains the best way of resolving this and holding, in fact, it remains the glue that holds the society. Because the resolution of the disputes will help parties know their rights, at least especially when it has been decided with some note of finality, and people will be guided accordingly. And in making plans or in taking decisions, people will be guided by such emphatic and final decisions. We can't have it differently. The judiciary remains the last hope of the common man. Even though the common man may not always feel that the judiciary has met that hope, that his hope has in all times been met, and that he has every reason to be grateful to the judiciary. But without the judiciary, the common man may even be much more endangered.
You know, when I was growing up, there's this sticker that used to be on cars that it struck with me since I was a child. Don't just get mad. Get a lawyer.
Yes.
You understand? And it was like, it was nice to think about. But for a lot of people, cost of seeking justice, is it in time? Is it in money? Is not what encourages one to get a lawyer. What's your profession doing?
Let me just tell you that it's not a Nigerian problem.
Okay.
I think in England or United Kingdom, they have a problem of overcrowded prison facilities. So more people are being given some kind of suspended sentences or social or community services because their prisons are not enough. Of course, their prisons not being overcrowded. In our own case, it will just be like, that. Because ours have sometimes 4 times overcrowded than they should be. But the point I'm making is that it's not a Nigerian thing. So growing societies and the growing ability of the state to detect crime and investigate them and seek to punish for them, more people will end up in prison. And many things that were not offenses before have now become offenses. So many more people are being jailed. And in many countries, it takes an average of about 2-3 years for a matter to get to court. So why we say this in our case is that it takes a very short time, constitutionally not more than 48 hours in many cases for your case, especially where you're in detention, for you to be charged to court. So ours get to trial faster.
Okay. And
they may now take a longer time. But in the Western world, it may take 3 years for a matter to get to trial, but it could be finished in a matter of days or weeks. So they're adjourned day to day. Even though our Administration of Criminal Justice Act has provided, and of course the requisite laws in the state too have all provided for day-to-day adjournment. In reality, our Nigerian courts are not able to put that in practice because they also adjourn other cases. I mean, from what I see in movies and other news reporting of courts, when they are doing case of A versus B, they only do that case. They do it from morning till night. But here you do this one for 30 minutes, 1 hour, you adjourn, you do another one.
Yes.
They don't do it like that. So sometimes comparing apples and oranges will give you the impression that our delay is worse than. But generally, we have a delay that is terrible. And we have a system that allows lawyers to, that hitherto allowed lawyers to take interlocutory appeals, stop a proceedings, and go all the way to the Supreme Court before coming back. In the criminal sector now, that has been discouraged. But they still manage to try it in civil matters, so an interlocutory matter will go all the way. And while you're doing it, sometimes the matter does not go on at the trial court. And it may take you like 12, 14 years, or 15 years to get to the Supreme Court for the Supreme Court to say the judge was right or the judge was wrong. Go back. In many countries, that would not happen. So we need to figure out a way of ensuring that interlocutory appeals do not stop courts from deciding a case one way or the other, so that parties can go on appeal and then know where they stand. So, yes, there are delays. The cases could move faster, but it's also not helped that we have a system where the Constitution brings about a breakage in the ability of courts to hear matters during the election cycle, by loading them, especially the Federal High Courts, with pre-election matters. And then when the elections are conducted, judges are uprooted from their courts and their division and posted to other states to sit on election petition tribunals. And then the Court of Appeal and the Supreme Court will have 60 days from the date of the appeal to render judgment, meaning all other matters are suspended. When you factor in all these factors, you also see why some cases don't move well. And where a judge is transferred, oftentimes the cases being handled by him will have to start afresh before another judge. Or where they don't start afresh and the judge has an assignment order, he can only come when he's not sitting in his primary place of posting. So we have all these complications that occasion delay. And of course, lawyers have a role to play. Yes. Sometimes we deploy gimmicks that are aimed at either frustrating trials or ensuring that they move at a slow pace or don't move at all. Prosecutors charging matters to court without proper investigation,
and then
putting too many charges that they have no way of proving or they cannot prove, wasting so much time, witnesses not being available, and sometimes also the courts, sometimes losing control of their court, not taking charge of their court, or playing into the hands of counsel and becoming a subject of appeal based on accusations of bias or real likelihood of bias. So there are issues, but we have all sinned. It would be unfair to single out any particular person like the judge or the judex, as we say, for blame. Because in many cases, it is a multi-sectoral thing.
Yes.
Different category of persons have one role or the other to play. And it is also heard that sometimes the facilities are not there in the court. Some court buildings lack lights. Judges still record in long hands. The record keeping is poor. Retrieval of information is bad. In some courts, you see files stacked on the corridor. If the trains, the courts are flooded. Some courts have no proper roof. They are leaking roofs. Even where counsel and litigants sit is an apology. So the court infrastructure is not there. And sometimes too, the judiciary workers are not quite incentivized. They're not well paid. So you have a situation where the constitution has been amended to ensure that the salary of judges has been enhanced.
Yes.
But that of the people who will do this work with them.
Arbitration is supposed to be another way of settling disputes, where if my understanding is right, correct me if I'm wrong, please, where the judge can say, do you people want to go and settle and talk to yourself outside the court? Do you think in Nigeria, we're not taking advantage of that well enough? Which is also leading to everybody trying to see that it must be the judge that settles it once the case is in court.
It's not a straightforward thing, because the issue of arbitration comes with cost.
Okay.
So some people don't understand why they have to pay an arbitrator to decide for them, and they still have to pay their lawyers.
Okay.
when they go to court, they only have to pay their lawyers. So arbitration in that sense is much more expensive than litigation.
So what are the pluses?
You see, some people say that the very reasons why people go for arbitration, they are fast, they are cost effective, parties are able to determine people choose it in other countries, are the very reasons that are making arbitration uninteresting in Nigeria.
Okay.
So the advantages elsewhere have become the negatives in Nigeria. Many lawyers in Nigeria even go into that arbitration with a litigation mindset. They go in with a mind of not even yielding a ground. They don't even think they should consider anything. They raise the kind of objections that are mostly raised in litigation. And then the charges, like I say, you pay for the arbitration, you pay for the venue, you pay for those who administer it, like the registrars. And at the end of the day, you win. You still have to go back to the court to bring his coercive powers to help you to enforce the arbitral award. And prior to the 2023 Amendment of Arbitration and Mediation Act, it was much easier. It was much easier for counsel to have so many reasons to attack an arbitration award. Under the Extant Act, the reasons have been narrowed down.
Okay.
But it hasn't much been tested by our courts. So sometimes you spend so much time and money in arbitration only for you to go back to the court and start afresh, as if to say that it would have been better if you had litigated from the award. So parties are not taking advantage of it as much as they should. Some of the practitioners are not making it easier, and some of the clients worry at the huge cost of the arbitration.
Okay, let me take you to the point you raised as regards the state of some of our courts. I had a reason recently to go to a magistrate court here in Nasarawa, and I was left speechless. If this is the house of justice, what quality of justice can you get here?
In many states, people are appointed magistrates and they have nowhere to sit. Some share courts. So you have a situation where 3 magistrates may share a courtroom. One person sits in the morning, somebody comes in midday, the other comes afterwards. Some will sit in their chambers, even when they know that it's not constitutional to hold hearings in chambers, but it happens because they have nowhere to sit. That's not just fine. Let me make a point though, that a court may be dilapidated, may sit under a mango tree and give you better justice than that court that sits in an ornate courtroom that looks better than a boardroom. But then again, the person sitting should sit in a conducive environment that gives confidence to people coming there that this is indeed a house of justice. And there's not much investment in that, especially in the States. Some don't even have chairs for people to sit in. Some don't even have any source of power supply. And it could affect one's spirit if the environment is such that whether your spirit, whether as a litigant, the counsel, or even the judicial officer here sitting there, and may give you impression as a human being that this one is not justice. So this case, this out of the way place that is falling down, can anything good possibly come out of it? Notwithstanding my earlier statement that such a court can still give justice, but the impression you get, your perception is that it's doubtful. And the confidence, as we say in law, is rooted. Justice is rooted in confidence. You must have confidence. That is why if there's a mere suspicion that a judex is likely to be biased, or that from his action or relationship to any of the parties or counsel, that judge's decision may be liable to question. Sometimes it's called real likelihood of bias. Not that the person has wrong, but what would a reasonable man looking at this, knowing, for example, that this man is my father, or that I drink with him every day, we share the same room and we all appearing before him, and I'm a litigant, can he be expected to do justice to me in my own cause? So that perception is very important. It is that perception that makes you know that John is the one wearing the masquerade, and you see him and you run away. Or in some place say it is a spirit. It is the air of mystery, and it should give you confidence that we are going here, that these people are God's disciples on earth, that they are next to God in terms of determining what is right or wrong.
Let's take a short break. When we return, we will consider how to address disobedience to court orders especially from government authorities. Stay with us. Welcome back from that short break. I think I'll take you, let's go back to the way of courts and perceptions and all that. We have, it seems, a lingering problem with obeying of court orders. In short, when the new CJN came in, part of what she said was that was going to be a no-no anymore. Where disobedience to court orders appears to be what is done in a lot of times, especially by government officials. I even remember that the Supreme Court during the last administration came out strongly to say the president appeared to have signaled wrongly by disobeying a court order. How do we address, in your opinion, this case where it appears a judgment is given and government, whether at state level or at federal level, seem to disregard it?
I don't know. Let me preface my answer with a story. A few years ago, somebody complained to me how his rights were violated by a policeman, and then lamented, and I said, well, you have a constitutional right to enforce your rights. You could sue the policeman and his employers and all that. I said, what for? I said, of course, you get to them and say that he go and spend so much money in addition to his hurt, and even if he gets judgment, he can't enforce it against the police. And I tell this story to show how even people are losing confidence in the ability of the courts to give them justice. Not because the courts will not entertain their case and rule in their favor, but because the process of getting the benefits of that judgment are oftentimes a mirage. We have a provision called Section 84 of the Sheriffs and Civil Processes Act that says that you need the consent of the Attorney General to get money under the custody of the government. And so whenever you go to enforce a monetary judgment, the executive resists it. The government agencies resist it, citing that section of the law as the authority for preventing you. I hold the view it amounts to giving power to the Attorney General to supervise the enforcement of judgment of a court created by the Constitution. And the Constitution has given the courts, the court that gave that judgment, and other courts the power to enforce judgments of superior courts. I'm told there's a recent judgment of the Supreme Court, but there seems to be some disagreement. Some say the decision by Honorable Justice Ogunwumiju that provision of the law is unconstitutional was not the majority view of the court. I've not made out time to read it, even though I've obtained that judgment. I'll read it this weekend. I give these stories to show how, by refusing to comply with orders of courts, the governments are setting a bad example. There's no worse thing a government can do than showing the citizenry that it does not have respect for the courts, which form parts of the organs of government. It emboldens the big men, the big women, the rich men in society to also defy court judgments. So you get judgment, you have it in your hands, but it's no better than a worthless piece of paper because of the difficulties. And some people struggle to enforce judgment and die without reaping the benefits of those judgments. And governments, whether local governments, state or federal, routinely pick and choose which judgments they will obey. The Supreme Court gave judgment on local government autonomy. Many state governors are finding it difficult to comply with that judgment. And we're still talking about the need for people to obey the law. And I keep saying this, people will not respect us. People will not come to Nigeria to do business. There will be less and less foreign direct investment if investors do not think our court system, our justice system works. If they do not have confidence in the ability of our adjudicative system to resolve disputes between parties, for so long will they go elsewhere, or for so long will they come here and insist that in case of a dispute between them and their Nigerian partners, whether be it government or individual, that such matters can only be settled in the courts of another country or by arbitration held in other countries. So what have we talked about? Loss of confidence, a negative business outlook or climate, capital flights, the foreign exchange will lose and pay when we travel to do these matters there, or pay arbitrators, or pay foreign lawyers to represent us or act for us. And also, what message are we sending? Our court system cannot be trusted. You can do business here, but if there's any problem, find your way.
And this is an economy where we're hoping to grow.
We are not hoping to grow it. We are hoping to make this place not only a tourist destination, but a business destination.
Yes.
We keep struggling to improve our standing on ease of doing business. But if our judiciary, if our judicial justice system does not engender the confidence that people require to come here to invest, to have the assurance that disputes will resolve not only justly, but in a timely manner, they won't come.
And it seems the government that is driving.
The government has to drive this. The government must be exemplary, because some of these people also have things to do with government and regulatory agencies. They also want to know that this government is subject to law, will respect the decisions of his own courts. So it is even in the government's best interest to ensure that not only are that judgments and orders of courts are obeyed, but that it itself makes it clear that it also obeys it and is bound by it.
Even though the contrary is what we have, they are the ones that
would appear there. Yes, majority of the judgments that are difficult to enforce are against governments.
And just you brought up that local government case. We have the one of Edo.
Yes, the governor comes in and says whether he has dissolved or he has suspended council, and despite the advisory by the Attorney General of the Federation, the governor remained adamant, despite so many decisions of the Supreme Court, that no governor has the power to remove or suspend the local government chair or dissolve the council. It is still happening. Lawlessness. Because those who are elected officials see themselves as above the law. Executive recklessness.
So the question in the mind, I'm sure, and I'm sure it will be echoed, where does this lead us? Where we have a situation where it appears with power you flouted, and we're expecting the same people who flouted to be the one to enforce. Is there an amendment? Is there an amendment we can make to address this?
Now, let me say this to you. In many of the areas where we are struggling, we patterned our laws after laws made in other countries, or even some United Nations model laws. It's not about the absence of proper laws. It is the absence of the political will to enforce these laws. It's the absence of fidelity to our laws. It's the absence of subjugation to the rule of law and due process of law. It's our ability to feel that we tower above the laws. And because, like I said in a TV program, the actions don't have consequences. You can do anything, be governor for 8 years, be president for 8 years, and go home. You can send troops to wipe out a village and knowing that nobody will bring you to trial, that your successors will not revisit it. You can do anything, break people's legs. Know that even if they get judgment against you, nothing will happen. Or you can even prevent them from getting into court. You can get an injunction against those you have offended. It is our ability to either manipulate the system or to make the system not to work, and to show no respect for the system. All of us are victims, we're all casualties. Because at the end of the day, we all have a price to pay. Because they continue to erode confidence in the system, and the perception will always be negative.
And at the end of the day, the government is still out there traveling, trying to get people to come in and invest, not understanding that this is...
Did you ever see the government of Rwanda travel to any country to encourage people to come? They changed the system. They put out the story there how good the place is. Today, Rwanda is a tourism destination, is a business destination. Nigerian companies go there to have retreat. Even government agencies, they go there for their meetings. They go there for all manner of things. When your home is cool, when things are working well, people will know, they'll find you. It's not about what you say. It's about what people see you do. And when you're doing it well, people will come there. They know that whatever they are doing, the laws are there to protect them. So when the story out there is that you have scant regard for your law, market it for no matter how much. No matter how much perfume you put on that pig, people will say, see it as a pig, if indeed it is one. So if your system does not work, you can't fool people because they will know. And they will not come. And only a few risk takers will come.
So we have a lot to do with our judicial system, understanding that it has implications for economic growth.
No, I mean the executive.
Yes.
The judiciary understands, but they can't keep. The judiciary does not have an army. It depends on the executive and the agencies and organs to make things work. They can make a pronouncement. Why they have their own responsibilities and their own problems, ensuring that the law works, that the judgments are certain, that people can advise their clients with certainty and ensure that there are no inconsistencies in their judgment. The greater work lies with the executive to make for a conducive environment, to ensure that the laws made are executed, the judgments given are respected and enforced.
Okay. Thank you. I think that message, I think, is well and truly made. I would like to take you up on we've started going into the electoral cycle again. And I'm not sure how well we've recovered or learned from the last electoral process we had. From your own experience, and I take very seriously your length of time in the judicial arena, what's your perception of how we fared with the judicial pronouncement and processes following the 2023 elections?
Well, generally, the judicial pronouncements were good, but in few, it is my hope that a few of these judgments or decisions will be revisited. I think, unarguably, the Electoral Act, I think 2022, is one of the most progressive electoral laws we've had in recent years. They try to put in provisions to make for example, proof in electoral matter, section 137. But I'm worried that judicial pronouncements with respect to that section has made it difficult. Where that section says that you should produce documents, you don't need to give evidence. But judicial pronouncements, which seems to say that you still have to give evidence about them, failure to call evidence makes it worthless. The documents are not enough proof by themselves. Even when we say a lot that the document speaks for itself. And when the court gives you only 3 days or 4 or 5 for calling evidence, and they now say that you should have called somebody from all over the place, knowing the impracticability of it, I think the court may need to look at it. The other one emanates from the electoral presidential election, that a subpoena witness had to give witness statement on oath, and that without it, whatever evidence he gave goes to no issue. It defeats the essence of subpoena. And then the issue about beavers, the reading from it, whether you have to tender the machines in court, these are decisions that I hope that in the next electoral cycle we would have to revisit, because they don't seem to make for practical resolution of electoral disputes. People cite examples of Kenya, Uganda, and other countries that are able to conclude their hearing within a short period of time. And these hearings are concluded before people are sworn in. We don't need 6 months to resolve electoral disputes as we have in Nigeria at present. We don't need 6 months to resolve electoral pre-election matters. Personally, I am of the view that pre-election matters should not be justiciable. Now, that internal affairs of a party, if a party by whatever misselects a candidate and does not prefer another person, should not be a matter for the courts, because these matters are overburdening the courts, and they have not improved the perception of the ability of the courts to give justice. But I also think there is need for the court to revisit their position on what is the legal status of guidelines made by INEC. I thought that being what we call subsidiary legislation, they had the force of law, but some interpretation would appear to suggest that they are not. Mm-hmm. That some of these areas will need clarity in our laws, so that people will be able to know how to plan themselves. So that if INEC conducts a free and fair election, people will not just activate the judicial process just for the heck of it, just to show I did not lose. So that their supporters will have the comment, oh, it is the court that robbed them of victory. And I think another thing we need to look at, has this idea of not trusting judges to determine cases arising from within their state, has it improved anything? Transferring judges to different parts of it, incurring cost of relocating them, housing them in hotel, paying allowances. So under the 1979 election constitution, judges resolve the electoral disputes arising from within their states. Can't we revert to that? Will it not make that? And all electoral disputes were resolved before swearing in took place. We may need to revisit all those things and consider going back to them, because what we have adopted does not seem to have progressed more, has not engendered much confidence in the people. And we should give them a second look and also continue looking at our electoral laws to ensure that they work. I was part of the Yaga Africa observer mission to Ghana, and I saw their system, and I saw the level of confidence people had in them. And I saw how, even before the official results were announced, because of the transparent tabulation of the results in largely parts of Ghana, the man that lost, who was the incumbent vice president, picked up his phone and called John Mahama, who was later declared winner, and congratulated him. They didn't have to wait. Why won't the result tabulated at the states be accepted? Why must it be the one that is tabulated in Abuja? that is considered authentic. And I saw the confidence of people, how the process works. Even you, without knowing much about it, will say, look, this is a system that works. On the accreditation and all that, when they say rejected, it will say rejected. Everybody hears it. For accepted, it's accepted. And all the polling agents have copies of the electoral register for that polling unit or polling, whatever they call it. And they could confirm that it is you. Simply transparent. Have a way there are the regions where the systems are collected on the fax machine where the results come in. We can't seem to make up our mind what is the functional basis for IREV. And so people allege that in Nigeria today, the problem has moved from the polling units to the collation centers. And that sometimes a lot will happen between the hours of darkness and morning when final declaration is made. So, and judicial decisions can help streamline these things and stop the rot and the downward slide.
Okay, but how do we, when you say this should be looked at again, what do you mean by that? How do we get them reviewed or looked at before the next?
We may need to amend the laws if the judicial felt that some things were not settled in the way the laws were drafted. They will do that. I understand from a program I attended where the chairman of the Senate, Senate Electoral Committee, just said that they're having engagement with all major stakeholders, including the judiciary, maybe to provide an opportunity for these things to be harmonized and the laws to be amended to ensure that decisions in this context do not produce results that make for impracticable situations.
What of it's the interpretation? Because from what you're saying, it appeared the amendments or the reforms looked good, but the interpretation...
So that's for the point I'm making. If those who interpreted them felt that the language of the phrasing was somewhat vague or ambiguous, they say stating they are deciding the way they did. Suggestions could be made on how best to draft them, so that the true will of the legislature will be reflected, so that you can't have a situation where I produce document. You say, because I did not bring somebody to talk about it, that document is useless. There's so much we could do.
But do we have the time? Taking into consideration
if we're serious about it, we have the time. The next election cycle will be in 2027. This is just 2025. That's enough time.
No, sometimes getting our legislations...
No, if we're serious and committed, the same way they're able to pass budget and other things they can pass in the door too, they can pass them.
Okay.
If we all know that it is in best interest of the country and our future that this be done, with all hands on deck, why not?
Let me take you on the issue you also raised as regards the time. First of all, the issue of pre-election matters. If I understood you correctly, you were like, you would have said it should be the internal.
No, I said pre-election matter. Issue of who is the rightful candidate of a party.
Yes, but you also know that what came out of that was where the parties didn't have internal democracies and they were now being
used. They have it now?
Yeah, but if they still don't
have it now?
The court will be the place. The court will be the place where whoever is.
Do you know what it has done? It has led to a situation where we have what we call the allegation that we have judicialized the political process, that the courts are now choosing candidates. There are political parties. If they do not have internal democracy, let the electorate punish them for that. Let the members who will leave them for not having internal democracy show them that you cannot thrive without democracy. It should not be a judicial matter. Because also, all the matters that have gone to court have not shown that there has been any improvement on the part of parties, that the parties have grown wise and become more democratic. For as long as you keep changing things, the political parties will keep evolving to find ways to evade doing the right thing.
And push the...
So if the electoral process works and system works, and people will be able to, votes will count, political parties will not behave the way they like, because they know that voters may reject them for taking away ticket from a popular person and giving it to an unpopular person. But because sometimes either money influence or some other influence affect the outcome of an election, they do anything they want to do.
What of the post-election matters? You spoke about the issue of swearing in.
You see, in other countries, how many cases go to court in so many other countries? If the electoral system is simply transparent, people accept the outcome and go home.
And even
that's a matter working on INEC. If the system works, at Ghana, how many cases went to court? In South Africa, how many cases go to court?
Or Rwanda.
So when the system works, When the Electoral Commission is independent and acts in a very transparent manner, that people will laugh at you for saying you did not lose when you lost, the courts will be free from most of these disputations.
Okay, but do you feel the timing we have right now is sufficient? Because I know the last reforms, part of what was taken into consideration was to try and see that enough time was given to try and resolve some of these issues before.
Did we resolve any? Did they not spill over till after the people have been sworn in?
They did.
So we should shorten the time for resolution of it, as I said earlier.
And then move
You know
forward.
what Shakespeare said? He said it's not in our stars, it's in us. The problem is not in our stars, it's in us. We are not caused, we are the cause.
I hope we'll take that to heart. Let me take you to one issue that a lot of people look forward yearly and not for the right reasons. Your MBA conference. I know another one is coming up.
Yeah.
Unfortunately, we used to have time where it will appear there was always one issue, whether with bags or something. You now see videos. And, you know, with these new young lawyers and social media, it appears nothing happens before you know it is everywhere. Your MBA conference is coming up. What should we look forward to this time?
Larry, with reference to what you referred to.
Yes.
In journalism, they say that bad news sells.
True.
If a dog bites a man, it's not news. But if a man bites a dog, that's news.
Yes.
So you may have a wonderful conference and a little incident is what defines it. So, but the important thing is that we're trying our best. We started early with the conference planning for this year's conference. The conference will take place in Port Harcourt. Unfortunately, at the moment, only 3 cities have the capacity to hold a conference. That's Abuja, Lagos, and Port Harcourt. The 2023 conference was in Abuja. I was the chairman of that conference planning committee with Mrs. Oyinko Badejo Okosonya. I was the alternate chair. The last year's conference she chaired it was in Lagos. So the next point of call will be Port Harcourt.
Yes.
So we move from one city to the other. We are doing our best, starting early, to ensure that some of the hitches we have learned had in the past, we overcome them. We'll try to avoid, it's good to learn from the mistakes of others or from the past. So we are doing our best to ensure that those things do not define the conference, but rather that the issues that come out of the conference, the conversations we have and resolutions we take will be what people with their phones and their gadgets will put out in the news to define the conference. Will the people going there to make a difference, leaving them better than they went there? That we believe, we're hoping, we define the conference when it finally takes place in August. We do not pretend that we are perfect, but we guard against any avoidable error that may mar the conference. And we're trusting God that everything will go well.
Okay. Now, let me look at your tenure. You look at your tenure from your campaign promises. There were some things you set out. Which one would you say you are hoping by the time you finish will be the one that would define your presidency?
Our advocacy issues on rights of persons who are detained, pre-trial detention persons or what we call awaiting the trial persons. Having the MBA be constantly advocating for issues and making a difference in the lives of the people and fulfilling these people's expectations as to what the bar should stand for. We are an advocacy group and a pressure group. We're not a political party and opposition group. So we speak on issues affecting the administration of justice, and we speak on issues affecting the practice of law and the welfare of our members. And it's my prayer that when I leave office, the time and attention we have paid to some of these issues will define my presidency and what I would love to be remembered for.
But how is that going?
So, so far so good. We've just done 6 months, and we're hoping and believing God that we'll do better in the remaining 1 year and 6 months.
Okay, but this one you brought up now reminds me that recently the End Bad Governance happened, and it appears you took a role in that.
Well, what we did was that when they were charged to court, we directed our branches, their Human Rights Committee, to be present in court to observe the proceedings and to provide free legal services to people who may be in need of it, and also give assistance where possible, to draw attention to the fairness of the trial, to ensure that those who are tried had their day in court, had a fair trial. And that's been very, very good. And that's part of what I was saying, MBA, playing the role the society expects us to play. And also respecting the way people want to demonstrate, respecting their rights to demonstrate, and calling on law enforcement agencies to protect them, not to shoot them, not to disperse them forcefully or put down their demonstration. And also calling on those who want to demonstrate to respect the rights of those who do not wish to demonstrate. It's a two-way traffic. I can refuse. So playing our roles as gatekeepers, as advocates for protection of the rule of law, because our motto indeed is promoting the rule of law. And in this, we are not partisan. We do not take a side, but we ensure that the justice system works well and society works in an orderly manner.
Thank you very much for your time.
Thank you
really
so very
appreciate
much,
it. Thank you.